Before the court involving this defendant, 14 CR 125, 14 CR 206, and 20 CR 92. This hearing being conducted on Zoom. Ms. Haynes is occurring from the Justice Center. Our attorney is Catherine Hacker, occurring from her office, occurring from prosecutor's office. Okay. Also, we have Probation Officer Carr and Drug Court Coordinator Sturgill also present. The matter before the court is an evidentiary hearing regarding the alleged violation of the terms of the community control by a defendant that was filed on March 7th. The court appointed Ms. Abner to represent the defendant and set the matter for a hearing, and it was continued, request counsel, and the matter is now before the court. Now, Ms. Abner, we had an opportunity to review the allegations with your client. All right, and we're going to be having a hearing, or will there be admissions?
She will be admitted.
All right, Ms. Haynes, the allegations that were filed on March 7th, alleges that you violated the orders of November the 8th, 2019 and August 6th, 2020, in that Rule 2, that on or after 12/23/21 you failed to report. Rule 7, that on or after 12/9/21 you failed to follow the drug testing system. And on or before 3/7/22, you used methamphetamine and amphetamine. And Rule 13, that on or after 11/24/21, you failed to provide aftercare mental health counseling. And on or about 2/11/22, left Georgia Harris House against staff advice and never returned. So you are entitled to have a hearing in these matters, and that's what we're here today for. In which the state will have the evidence and proof to the court's satisfaction you violated these conditions. You have our name and attorney cross-examine the witnesses the state presents. Now, in the event that you may also testify on your behalf, and that evidence on your behalf if you wish to, you're not required. Now, in the event that it's found that you have violated these conditions, whether it be by your admission or by a hearing, one of three things can happen: like continue to control of the same conditions previously ordered, continue additional conditions that may be appropriate, including extending your total supervision term to 5 years. And the third, most serious, like to revoke your community control, sentence you to prison in the 20 CR 92 case for 12 months, 6 to 12 months. In the 14 CR 125 case, that would be, let me find that here. I forgot. That would be to possible term of 36 months in count 1 and 12 months in count 2. And then in the 14206 case, that would be to a possible term of 2 to 8 years. Now, do you understand the allegation of the issue, Ms. Hayes?
Yes, sir.
You understand the possible consequences if you commit to these violations?
Yes, sir.
Has anyone threatened you in any way or promised you anything in case you make these admissions today?
No, sir.
Do you have anything you'd like to speak to your attorney about before we go any further? I can push you into a breakout.
No, sir. I just like to have the proceedings now.
All right. Then do you admit or deny the allegations that were filed with the court on March 8th?
Admit.
March 7th, I'm sorry.
Admit, sir.
All right, thank you. All right. Anything from the state or the probation department?
Thank you. The state would just ask that the defendant may continue on community control and with the Big Star program. Thank you.
Ms. Hackner?
Thank you, Your Honor. Your Honor, as the court is aware, Katrina has some mental health issues. However, she successfully completed drug court. She then had some issues. She went to Georgia Harris' house and was, I think, actually doing fairly well there. Unfortunately, she left Georgia Harris, and that's when some of these immediate issues came up. She's been in custody for approximately a month now, I believe. And while she's been in custody, she's been reassessed psychologically, and she's back to some of her medications. There is another medication that she was recommended to take, however, it requires a blood draw before that she can start that prescription. And unfortunately, that wasn't done. We continued this hearing for to get that blood draw done so we could started that medication, but the blood draw was never actually taken. So she is still awaiting that prescription, and that's the result for us. So we would ask that she continue to keep control, that because you're not getting blood draw done in jail, that she be released so she can get that draw done and start that medication. I think that from my perspective at least, Katrina is not a bad person. I don't believe that she's a danger to the public. She just needs to be able to continue medication so that she can address some of those issues. And we believe that if she is released and continue to community control, that she'll be able to maintain that.
All right. What's the medication that they thought she might be needing?
And I'm going to have to ask Katrina to answer that herself. It was Vivitrol.
Oh, Vivitrol.
Yeah, and I recently I got on the right hand, I think ADHD. The counselor's been coming to see me, and so I take Valley since I've been in here.
Okay, so you are getting that medication.
Yes,
Right.
but just not blood.
And Ms. Sturgill, if you know, there's none of the medications she's taking are just qualifying her for STAR.
Yes, sir. I actually confirmed with STAR this morning. There is a bed available on April the 13th for her. They are agreeable that she would be eligible for weekly mental health appointments at STAR, and they would also consider on the Risperidone, that is the permitted medication, and of course we could seek the Vivitrol at STAR also.
Okay. All right. Anything you'd like to say, Ms. Hayes?
I just like to apologize for being back in the report. I was doing really good. I'm gonna cry. I was doing really good. I just kind of also referred to me. That was like the opportunity, I took a few steps back, but I didn't have like the time. I have a lot of support. Steppers in my permit, and have a mission to be with my parents where, I should have been all along, instead of being so stubborn to stay, on my own and independent. So I just, I took a few steps back, but I think I took enough to where I can't bring myself back.
All right. Well, yeah, Ms. Hayes, you did successfully graduate drug court. You've done very well. Your downfall was your failure to comply with mental health needs, I believe, is what seems to be the consensus. Sure.
That switch, and it took my saying you what I was thinking, and I really enjoyed, Mr. Vinny. It's working so well, and I feel comfortable with him. It takes a lot for me to open up. I'm kind of like, I've done STAR before, and I was seriously full. Opportunity there, and I am comfortable with it, and I am someone who takes a long time to open up. But of course,
Well, I think that the best, I'm going to continue to control several conditions. First is extend your total term of 5 years of supervision, so that there's some time to make sure that you can be stabilized. I'm going to order you to complete the STAR program successfully in aftercare, because I think right now, I think you need that structure and that controlled environment. You'll remain in custody of the sheriff until the conveyance STAR on the 13th of April. You'll be required to pay court costs, and your aftercare includes mental health as well as good patrol. If good patrol is indeed, I'm not sure if it is needed because it seems to rely on that. And amphetamine is not opiate, so, there doesn't seem to be any alcohol involved, so I really don't think you need good patrol unless there's some history there that I'm not aware of. Maybe there is, if there is, then of course that evaluation will determine that, and, you'll have to do blood draw to see if you're, okay to take it, but, I'll leave that up to them. They'll evaluate that as well. So, that'll be the order of the court, and, hopefully, main thing is you need to continue to be aware of your mental health issues. So I think if you've been able to address those, and I understand the effect of the side effects of medications, but the thing to do is not quit taking them, but to try to work with your provider to get something else that works. It's not, doesn't have the same side effect. But sometimes there are some situations where that's just a happy necessity to suffer through side effects because the side effects are less than the effects of the issues that you have, which is back here in the custody. So, try to keep that in mind. All right, anything further, counsel?
There you
All right, so you're remanded back to custody until we start next week. Thank you. This is case number 210110, State of Ohio versus Ronald Hausman, second. And are you Ronald D. Hausman, the second, appearing from the jail? All right. Mr. Armentrout is present, representing defendants, and representing the state as Assistant Prosecutor King. Hearing is being conducted by Zoom, and Mr. Armentrout, you and your client both agree with that. And you are good, Mr. Housen.
Yes, sir.
Right now, any event you need to talk to Mr. Armstrong, since you're not in court with him, just let me know, I can put you in him and we'll break out, so we'll see if you can talk privately. No one else will be able to see you here, okay? Alright, the defendant charged in case number 21CR110 with malicious assault, second degree felony abduction, third degree felony domestic violence, fourth degree felony. Matter of set for a plea here today. The court had previously found the defendant been restored to competency and doesn't work for not guilty of reasonable insanity plea after evaluation by the Justice Evaluation Service Center. And I've been presented with a plea of guilty form in case number 21CR110. Also note for the record, the defendant is currently on duty control in case number 20CR85 for aggravated possession of methamphetamine. There was a pending evidentiary hearing on that as well, which was stayed after the issue of defendant's competency came up, and he was in treatment for a period of time before he was restored to competency, and therefore that matter is pending since that time. Now, Mr. Housen, in case number 21CR110, the new indictment, been presented with a plea of guilty form, says you're going to plead guilty to count 2, the abduction. I'm going to hold this up to the camera on my computer, and you recognize, you read your name and case number there, and it says plead guilty to count 2.
Yes, sir.
All right, page 3, there are 6 lines, and about a fourth of the way down, there's a sentence that reads, I enter this plea voluntarily, and then below that, there are signature lines. Right below it says attorney for defendant. Over to the right, it says signature defendant. And it appears to be Ronald Housen II. And I'll hold that up. Is that your signature there on the page? All right. When did you sign this agreement, Mr. Housen?
I think last week, sir.
Okay. And when you signed it, was you there? Was your attorney there with you to explain everything and go over with you?
Yes, sir.
And when you signed this, did you understand this agreement to plead guilty, which means there won't be a trial, and the next step in your case will be a sentencing hearing?
Yes, sir.
And think you had enough time to fully consider this matter before making this decision?
Yes, sir.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right, now the document says on page 1 that you're going to withdraw your non-guilty plea, plead guilty to count 2 abduction under 2905.0282 of the Ohio Revised Code of third degree felony. Further states that you understand that the maximum prison term for that could be 36 months in prison, the minimum could be 9, and at certain levels in between those 2 ranges. There's a fine available of $10,000. You understand that?
Yes, sir.
Now, are you facing any felony charges in any other jurisdiction currently?
Yes, sir.
All right, I know you're on probation for the case in 20CR85 in this court. Are you on probation for community control, gross release control, or parole for any other felony in any other jurisdiction?
Yes, sir. I only got that one covered.
All right. Now, Mr. Houseman, under the law, if you plead guilty to this new charge of abduction and the new indictment, one of the conditions in your other case, 20CR85, is that you obey all jurisdictions. So if you plead guilty to a felony, then that will also be a violation of your community control in that case. In that case, that's a 5th degree felony, which could result in you being in prison for a period between 6 and 12 months, and fined $2,500. And if that prison term is imposed, 12 months is the maximum in that case, and 36 months in this case. So there could be a maximum prison term of 48 months and 4 years. You understand that?
Yeah.
All right, now, under the law on this new charge, the abduction, if you plead guilty and the court sentences you to prison, once you complete your prison term, it is mandatory to be put under post-release control supervision by the parole authority for a period of at least 1 year and a maximum of up to 3 years. What that means is that they will set down certain conditions that the parole officer will supervise you on. And the parole authority does that, not the court. And if the parole authority finds that you have failed to comply with those conditions, they have the authority to return you to prison, make you serve an initial period of up to 9 months for any one violation, up to a maximum of half or whatever prison term was imposed for all the violations that might occur. But if you commit a new felony, then in addition to whatever sentence, while you're under post-release control, then in addition to whatever sentence could be imposed for the new felony violation, then that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year or whatever time is left on that post-release control, whichever is greater. If that occurs, that would have to be served consecutively to sentence in the new case. You understand that?
Yes, sir.
Now, I'm not required by law to sentence you to prison for this abduction offense, count 2. I could impose community control, which, as you know, means that you're supervised under conditions set by the court for a period of up to 5 years by a probation officer. And during that period of time, the probation department felt that you were not complying, then they could file a written notice of that court, serve a copy on you. There would be a hearing, and if the outcome of that hearing was that you failed to comply, then at that time the court could revoke your community control and sentence you to prison for 36 months. In this case, fine you $10,000 plus for 12 months, $2,500 in the other case. You understand that?
Yes, sir.
Right now, the charge that count 2 alleges that on or about June 6, 2021, continuing through June 7, 2021, in this county, you, without privilege to do so, by force dealt, knowingly by force dealt or threat, restrained the liberty of April Yates under circumstances which created a risk of physical harm to the said April Yates or placing her in fear in violation of section 2905.0282. So that's the charge of abduction, was the third degree felony, with possible prison term of 36 months, fine of $10,000. Now, Mr. Hausman, do you understand what it is you've been charged with, what the state says you did, where and how they alleged you did it?
Yes, sir.
Do you understand the possible penalties for that offense?
Yes, sir.
Have you discussed the nature of that charge, the evidence in the case, the legal issues of the case, possible defenses you try to raise a trial, possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
I take medicine, sir.
And are you taking that for your mental health?
Yes, sir.
Now, does any of that medication interfere with your ability to understand and to communicate effectively?
No.
All right, very good. Now, has anyone threatened you in any way to make you plead guilty here today? Has anyone promised, let me say on page 2, there are 3 lines printed in bold underline about 3/4 of the way down. It reads as follows. Defendant shall enter a plea of guilty to count 2. State will dismiss the remaining counts. State defense jointly recommend 2 years incarceration. State defense jointly recommend 6 months incarceration and 20 CR 85. Now, is that your understanding of the agreement, Mr. Hausman?
Yes, sir.
Has anyone promised you anything other than that you should plead guilty here today?
I get 10 months time, sir. That's what I'm still doing all over.
You'll get whatever credit you have coming, including any time spent in the hospital, yes. All right. Has anyone promised you anything other than that then?
Yes, sir.
Under the law, Mr. Hausman, if you plead guilty, the court is not required to follow the recommendation in terms of sentencing. So, plead guilty, the court will not have to sentence you to the time that's specified. I could, if I felt it was appropriate, sentence you to 36 months on this charge and 12 months on the other charge for a total of 48 months. You understand that? Right? Now, do you hold any, let me ask the prosecutor, have you consulted with the victim in this case and obtained her consent?
Yes, we have, Your Honor.
All right, thank you. Now, Mr. Hausman, do you hold any license or certificate from any state governmental body that regulates any occupation or profession?
No.
Right? You have certain constitutional rights, you must understand, before I can accept a guilty plea from you. First, you have a right to have counsel, Mr. Armstrong's appointed representative. Now, that wasn't simply for the purpose of working the case out, but provide any defense that might be available to you under the law that you wish it to provide. So, if you decide you don't want to do this, and you want to defend against this case, he'll continue to represent you and provide that defense, including a trial, if that's what you want. You understand that? Right, now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in this county to serve as your jury. And once those 12 were selected, they would hear the evidence, and then would be instructed on the law, and then that jury would decide by unanimous verdict between all 12 have to agree as to whether or not the state proved your guilt or proved beyond reasonable doubt. Now, if you did not want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means give up your right to have a jury trial, and in that case, you have to hold a full bench trial, meaning that instead of the jury hearing the evidence, it would be the judge hearing the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt or proved beyond reasonable doubt. You understand that? Right, now, under the Constitution, Mr. Halpin, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that the witness against you would have to come into court to testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. You understand that? Right now, in the Constitution, you have the right to use the power of this court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain going to come in voluntarily, it's your request. The court issues a court order, it's called subpoena, and force those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here. It's the same way the state's witnesses are required to come to court. You understand that? Under the Constitution, Mr. Halpin, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including the trial. No one can ever make a testimony. The prosecutor can, the judge can. You decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time of the proceedings. And in fact, no one's even allowed to talk about it except in one situation, which is if there's a jury trial and you don't testify. Then the judge instructs the jury that because that is your right, they cannot consider that for any purpose. You understand that?
Yeah.
Right, now, Mr. Halpin, of the Constitution, you have the presumption of innocence, which means you're presumed innocent until proved guilty by the state of Ohio of every essential element of the offense charged. So the burden of proof isn't on you to try to prove you're not guilty. The burden is on the state to prove that you are guilty. They must prove that by proof beyond reasonable doubt on all the essential elements of the offense charged, which is the highest burden of proof that's known under the law. You understand that? Now, originally entered plea not guilty, Mr. Halpin, not guilty plea, denied the allegations in the indictment, denied that you committed any crime, and then exercised or invoked all of the rights that I've just described for you. Now, if you change your plea from not guilty to guilty, that is the opposite of a not guilty plea. The guilty plea admits the allegations in the indictment, count 2, admits that they're a crime, and that you committed that crime. That plea gives up all the rights that I've described for you today, except the right to have an attorney, because you always have the right to have an attorney no matter what you plead. But with that exception, your plea of guilty gives up the right to a jury or court trial, gives up the right to confront witnesses against you to cross-examine for your attorney, gives up the right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. Gives up the privilege against self-incrimination because you say you're guilty, that's what she finds you guilty. And finally, it gives up your presumption of innocence because you say you're guilty and the state's not required to prove you're guilty. Then it also waives your right to file an appeal on any alleged violations of your rights. You feel could occur up to this point in the case. Now, if I should sentence you to the maximum sentence, for under certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing after being filed. You understand all that?
Yeah.
And are you a U.S. citizen, Mr. Halpin?
Yes, sir.
Right, now, do you have any questions about the charge or the possible penalties? You understand it?
Yes.
Do you have any questions about the plea agreement? You understand that? Do you have any questions about the constitutional rights of the claim? You understand that?
I understand, sir.
Do you understand the plea of guilty, what it means, what the consequences of that will be if you enter here today?
Yes, sir.
Now, is there anything you'd like to speak to Mr. Armentrout about before we go any further?
No, Your Honor.
Then is it, do you have any questions about anything I've explained this morning?
No, sir.
All right, then is it your decision to go forward and plead guilty to count 2, in the indictment, as well as admitting that by that conviction that you have violated the conditions of community control in case number 20 CR 85. All right, then as to the charge which alleges that on or about June 6, 2021, continued through June 7, 2021 in Miami County, Ohio, you did with the privilege, without privilege to do so, knowingly by force or threat, restraining the liberty of April Yates under circumstances which create a risk of physical harm to the said April Yates or placing her in fear. The violation of section 2905.02A2 of the Ohio Revised Code is charged with abduction, a third-degree felony, carrying possible prison term from 9 to 36 months, and an increase provided by law of a fine of $10,000, and also would result in the revocation of your community control case number 20 CR 85 and possible prison term of 26 to 12 months. How do you believe? All right, court finds on this day in open court, defendant was advised of all his constitutional rights, created a non-intelligent and voluntary waiver of the same pursuant to Rule 11. The plea is accepted and ordered filed. Defendant is found guilty of the charge as set forth in count 2. Counts 1 and 3 are dismissed. And the court further finds that because of the conviction in this 21 CR 110, the defendant had violated the terms of his community control, specifically Petition 1, that was filed on October 8, 2020. And therefore that will be revoked. The court will go ahead and proceed with sentencing forthwith. This is a stipulated recommendation on the prison term, and also the court will find that this new case was committed while the defendant was on community control in the previous case. All right, anything to say?
Only one contained in the plea agreement, Your Honor.
Mr. Armentrout?
I would ask the court to give serious consideration to imposing a sentence recommended by the state of 2 years and 6 months of probation violation. Ron, since he was restored to confidence, is not the same person that I knew before anyone's previous possession charge. I feel certain that Ron Allen today would not have committed this act. He's been fully cooperative. He's very, very remorseful. He's one person that medication seems to take turn around and thinking processes and how he behaves. Still going to have to put houses, have to be time that it gives him a chance to continue on the path depending on code for the public representation.
Mr. Allen, is there anything that you would like to say? You're not required to say anything, but I'll listen to what you might have to say. All right. Well, it's clear that you are a much different person now that your mental health is stabilized. But unfortunately, the offense you committed here is a very serious one, offense violence, and one that obviously is traumatizing to the victim. So it is a judgment on the court that prison term is necessary for that offense. And based upon the agreement of the parties, the court reviewed the file and other matters that have been brought before the court. This order judgment the court is hereby sentenced on count 2 to a term of 2 years in the Correctional Reception Center at Moran, Ohio. And Mr. Palpable was arrested, I believe, on July or June the 9th that you were arrested?
7th, sir.
7th, okay, 7th, yeah, okay. All right, and so I've calculated that out to be 303 days, and that includes all the time that you spent in the mental hospital being restored to competency. Now, in case number 20 CR 85, it's the order of the court that should be sentenced to a term of 6 months. Correctional Reception Center in Ohio, according to the sheriff. You were held in custody June the 9th of 2021 till June the 30th of 2021 for 22 days. Does that sound right, Mr. Allen?
I feel like I should.
All right. So you'll get credit on that sentence for the 22 days, so it'll be a total of 345 days in case. Upon completion of the prison term, you will be placed under post-release control under the supervision of the probation department for a period of at least 1 year and a maximum of up to 3 years, as provided by law. In the 20 CR 85, it is optional; they don't have to, and it will be limited up to 2 years. But we know that it will be happening in the other case. What that means is that you will be supervised in the terms that are set by the parole authority. If they determine that you have failed to comply, then they can return you to prison, make you serve an additional period of up to 9 months for any one violation, with a maximum of half of your prison term. So your total prison term in these two cases is 30 months, so that would be a maximum of 15 months. But if you commit a felony, then in addition to whatever sentence the judge in the new case would impose upon you, the judge would also sentence you for committing that violation in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. That period don't have to be served consecutively sentenced in the new case. Now, it's the judgment of the court that the sentences of 24 months and 6 months be served consecutively. The court finds that the offense on 21 CR 110 was committed while the defendant was on community control. In case number 20 CR 85, there are 2 separate portions of conduct, and one single sentence will not adequately reflect the seriousness of the offense, and the sentences that are being imposed are not disproportionate to the harm caused, and the defendant's history of criminal conduct has indicated that that's necessary to protect the public future claim. You're also going to pay the court costs, which judge will grant execution order, and if you fail to pay those court costs, Mr. Housman, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, and other assets that you have. If that doesn't collect it, then the court could order you to do community service once you fulfill your sentence, then a release from prison, not while you're in prison. And the court will give you credit for each hour you work in an hour side by the court. Each hour you work will reduce your credit by that amount, and they'll pay it. All right, is there anything further from counsel?
In the 110 case, Your Honor, did you say 303 days of meal time credit?
Correct.
Okay.
And 22 in the 20 case.
Did you prepare that entry or go to community control?
I will.
Okay.
All right. Anything further?
No, Your Honor.
All right, thank you. There's no return to service on this first half. All right. That'll have to be continued then. All right, are you Heather Sue Applegate, current at the jail?
Yes, sir.
Okay, this is case number 22 CR 14, State of Ohio versus Heather Sue Applegate. This Applegate is appearing by Zoom from the jail. Her attorney is William Armstrong, appearing by Zoom from his office, and appearing from the prosecutor's office, Assistant Prosecutor King, representing the state. This hearing is being conducted by Zoom, and I'm trying to use your time both in agreement with the matter being conducted by Zoom rather than in-person appearance. You're all right with that, just, okay?
Yes, Your Honor.
All right, now, if at any time during this proceeding you need to talk to your attorney about anything, since you're not present with him in the courtroom, just tell me, and I can put the two of you into a breakout room, or we just the two of you talking. No one else will be able to see you here, okay? All right, the defendant's charged with aggravated possession of methamphetamine in a second-degree felony. The matter was set for a plea today. I believe we have a trial date coming up, May the 19th. Now, the court's been presented with this plea form, this applicant, which indicates you're going to withdraw your non-guilty plea, plead guilty to the charge. I'll hold this up to the camera on my screen. You see the form there says your name on it and the case number.
Yes, sir.
Okay, and then there are signature lines. It looks like those go on the bottom of page 3. At the bottom, the last sentence says, I entered the plea voluntarily. And immediately below that is the signature of defendant Heather Sue Applegate. What appears to me, and I'll hold that up. Is that your signature there underneath that sentence?
Yes, sir.
When did you sign this agreement, Ms. Applegate? When did you sign this agreement?
Last Monday or Tuesday?
Right, and then Mr. Armstrong wrote that with you, explain everything to you before he signed it?
Yes, sir.
When you signed it, did you understand it's an agreement to plead guilty, which means there won't be a trial, the next step in your case will be a sentencing hearing?
Yes, sir.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
Do you feel you were rushed or pressured in any way in doing this?
Yes, sir.
And this is still what you want to do here today?
Yes, sir.
And you're entering the plea agreement voluntarily?
Yes, sir.
Right, the agreement says you're going to withdraw your non-guilty plea, plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 revised code, second-degree felony. Further states that you understand that the maximum penalty on that could be imposed by the judge is 8 years, the minimum is 2. Now that is the minimum sentence that must be served. Whatever the judge says, that's the sentence that has to be served because it's mandatory. There's no reduction of sentence available, early release of any kind. But because this is a second-degree felony, under the law, it is possible that adult parole authority could add as much as 50% more on top of whatever sentence that I would impose for this violation. And so that's optional, it's not mandatory, but they have to make certain decisions as to why they think you should serve more time. And none of us are really quite clear exactly what that means. That's something they do at that level, but the court's not involved at all. And so if you were to receive the maximum sentence in this case of 8 years, then that means that parole authority, the Department of Rehabilitation and Corrections could actually make you serve another 50% or half, which would be 4 years. So the maximum sentence could be 12 years. You understand that? There's also a fine available of up to $15,000 and a mandatory fine of $75. In a license suspension is permitted, but it's not required, of 6 months to 5 years. You understand that? But again, you understand that any term that the court has no discretion to sentence to do anything other than sentence you to prison for this offense. You understand that? Okay. Other than this charge, are you facing any felony charges anywhere else?
Yes, sir.
Are you currently on community control, probation, parole, or most recent parole for a felony?
Yes.
All right, now, if you're convicted of this offense, you will be sentenced to prison. Once you complete the prison term that's been imposed, the adult parole authority could or must put you under what's called post-release control supervision for a period of at least 18 months up to a maximum of 3 years. What that means is you'll be supervised on the terms they set by a parole officer because the judge is not involved with that. If they determine that you have failed to comply during that period of time, which again has to be at least 18 months, it could be as much as 3 years as a determination of the APA. If they find that you failed to comply with those conditions, then they can return you to prison, make you serve an additional period of up to 1 year, or I'm sorry, up to 9 months for one violation, up to a cap or maximum of half of your prison term for one or more violations. However, if you commit a new felony while under post-release control, then in addition, whatever sentence will be imposed by the judge in that new case, that judge may also send you to additional period, in this case of 1 year or whatever time left on it period of post-release control. And if that occurs, that will have to serve consecutively to the sentence in the new case. You understand that? All right, now, the charge in the indictment reads that on or about August 30, 2020 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, violation section 2925.11. So that's the charge of aggravated possession of methamphetamine, second-degree felony, with a mandatory prison term imposed by the judge between 2 and 8 years, with the maximum being up to 1 half added on by DRC. A fine of $15,000, a mandatory fine of $75, and a possible license suspension of 6 months to 5 years. Now, Mr. Applegate, you understand what it is you've been charged with, what the state says you did, when, where, and how they let you did it?
Yes, sir.
And you understand the possible penalties?
Yes, sir.
Now, have you discussed the nature of the case, of the charge, the evidence in the case, possible legal issues in the case, possible defenses you might try to raise in trial, possible outcomes of the trial with your attorney?
Go ahead.
Have you talked about the charge, the evidence, possible issues in the case, defenses you might raise, and the possible outcomes of the trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
That is good.
Have any threats made to make you plead guilty here today?
Yes, sir.
Now, on page 2, there are a couple of lines printed in bold, and then I see there's been one number stricken out and a new number written in ink. So I'll read that as follows. Defendant shall not plead guilty to the indictment, state defense trial to recommend 3 years mandatory incarceration. That's your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to plead guilty here today?
Yes, sir.
And again, under the law, the judge doesn't have to follow our recommendation. I could, if you plead guilty, impose any sentence I think is appropriate between the 2 and 8 years. You understand that?
Yes, sir.
All right, now, you have hold any license or certification from any state governmental agency that regulates occupations or professions.
Yes, sir.
Right, and you have certain constitutional rights, which understand before I can accept this plea from you. First, you have a right to have an attorney. Mr. Armstrong was appointed to represent you. That wasn't simply to work the case out, but provide whatever defense might be available to you under the law that you wish him to provide. So, if you decide that you do not want to do this, you will still have counsel to represent you throughout the case, including a trial, if that's what you want. You understand that? All right, now, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Hinds County that are subject to jury duty on your trial day. After they're selected, the evidence will be presented, and they will be instructed on the law, and that 12 person have to agree by unanimous verdict, between all 12 have to agree on whether the state proved your guilt of the case. Now, if you decided you didn't want to have a jury trial, which you didn't want to plead guilty, you could waive in writing, which means you give up your right to have a jury trial, and in that case, you would have to hold a court bench trial. You can set the jury hear the evidence, the judge will hear the evidence, the judge will apply the law, and the judge will decide whether or not the state proved your guilt by proving beyond a reasonable doubt. You understand that?
Yes, sir.
Right, now, under the Constitution, you have a right to rebut the witnesses against you and cross-examine your attorney. What that means is the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. As the prosecutor then asks a question, your attorney will ask questions that go cross-examination. The purpose of that would be to bring out evidence to help your side of the case. You understand that? Now, under the Constitution, you have a privilege against self-incrimination. You have a right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're uncertain going to come in voluntarily, you request for this court order called subpoena, and force those witnesses to come to court to be able to testify if they want to, but they don't want to be here, the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Right, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. Don't ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to comment about it, except in one situation, which is if there's a jury trial, you don't testify. The judge instructs the jury that because that is your right, they can consider it for any purpose. Do you understand that?
Yes.
Right, now, under the Constitution, you have a presumption of innocence, which means that you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof is on you to try to prove you're not guilty simply because you've been accused. In fact, in the law, you don't have to present any evidence at all at your trial in your own defense. You may, it's not required to. But whether you do or not, the burden of proof remains upon the state of Ohio to prove your guilt on every essential element of the offense charged by proving beyond reasonable doubt, which is the highest burden of proof that's known under the law. You understand that?
Yes.
Now, under the Constitution, when you entered your plea of not guilty to the charge, you denied the allegations, denied you committed any crime, and exercised or invoked all the rights I just described. Now, if you change your plea from not guilty to guilty, that is the opposite of not guilty plea. The guilty plea is this allegation in the indictment, this is their crime, that you committed that crime. That plea waives or gives up all of the rights that I've described for you today, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. Without exception, if you plead guilty, waives gives up the right to a jury or court trial, waives gives up the right to confront witnesses and issue to cross-examine for your attorney, waives gives up the right to confront witnesses and issue to cross-examine for your attorney, waives gives up the right to use the power of the court to compel or force witnesses to be in court on your behalf, same as the state. Wage gives up your privilege against self-incrimination because you're saying you're guilty, that's what you find you guilty. And wage gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you. Plea of guilty also wage gives up any right to file an appeal, which they could have had in this point of the case. And finally, it subjects you to be sentenced immediately by the court, which is what's like pleading. Now, do you understand all of that?
Yes.
And are you a U.S. citizen, Ms. Applegate? Now, do you have any questions about the charge and possible penalties? You understand them? You have any questions about the plea agreement? You understand it? Have any questions about the constitutional rights of the plea? You understand those? Do you have any questions about the plea guilty or what it means, what will happen at the end of that plea here this morning? You understand that? Is there anything you'd like to speak to Mr. Armstrong before we go any further? Do you have any questions about anything I've explained to you here this morning? Then is it your decision to withdraw your not guilty plea and plead guilty in accordance with the terms of this written plea agreement that we've just gone over? Alright, then as to the charge in count 2, which alleges that on or about August 30, 2029, in the county of Ohio, that knowingly obtained, possessed, or used Schedule 2 controlled substance, methamphetamine, in an amount equal to or exceeding 5 times the bulk amount, less than 50 times the bulk amount, how do you plead?
I'm guilty.
Alright, the court finds on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same, pursuant to Article 11. Please accept the order filed. Defendant is found guilty of the offense set forth in the indictment. Court will not order pre-sentence investigation and do find her guilty, by the way, based upon the procedure. But will instead proceed with sentencing forthwith. Mr. King, anything on behalf of the state?
Only one thing to say, Your Honor.
Crap?
I'm going to ask the court to impose a complete sentence of 3 years, another cooperative pleading, another one excuses. This was a possession case. This wasn't part of any of the other cases that we've seen come through. This was strictly involving never, like I said, she didn't get a better existence. Always wanted to tell them what she had done here, and I hope the court take that into consideration.
All right, Ms. Applegate, anything you'd like to say? All right. Judge ruled the court that you be and are hereby sentenced to the Ohio State Court for Women, Marysville, Ohio, to a period of 3 years, and mandatory incarceration can be no early release. Upon completion of that, or it is also possible that the adult or the Department of Corrections could require you to serve an additional period of 1/2 of that sentence, which would be 1.5 years more, so it would be potentially a maximum of 4.5 years. It will be at least 3 years as ordered by the court. None of that can be reduced. Now, upon your completion of this sentence, the law requires that you be put under post-release control supervision under the authority of the adult control authority for a period of at least 18 months, and it could be up to 3 years as they determine. And that means you'll be supervised in the terms they set by a parole officer, and if during that period of time they determine that you have failed to comply, then they can return you to prison to make you serve an additional period of 9 months for any one violation. But there is a cap of half of the prison term for all violations. But if you are convicted of new felony, then an additional whatever sentence the judge in this case would impose upon you, the judge will also authorize to sentence you in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater, that will have to be served consecutively sentenced in this case. Has there been any change in your financial circumstances since I appointed counsel for you in this case? Right, the court then finds that the defendant is not able to pay the mandatory fines, unlikely should be able to pay it, and with probation, there will be no license suspension. You are over to pay the court costs, which judge has granted execution order. If you fail to do that, then the court could order you, clerk to try to collect that various fees, including letter of bank accounts, wage earnings, other assets you have. If that doesn't collect it, then the court could order you to service once you've completed your prison term, not while you're in prison, but once you've completed it in this county, and give you credit for each hour you work in an earlier ASF or each hour you work to reduce your judgment by that amount until paid. All right, is there anything further, counsel?
Yes, on credit card.
Oh, thank you. 36 days, arrested on March 2nd, and that correct, Ms. Application, arrested March 2nd?
Yes, sir.
All right, so as of today, that's 36 days. Thank you. All right. I believe that's it then for this morning.
proceed.
Our next case number 21 CV 83, State of Ohio versus Lee Hensey. Present for the plaintiff, actually Highland County Mental Health District versus Lee Hensey. Since Prosecutor King is here representing the health district, and is not present. This matter was set for a hearing on the 10th. It was set for February 28th at 2 o'clock after she had been served. The court received a phone call from her on February 23rd asking for an extension of 30-day extension. Said she had double pneumonia, just got out of the hospital on February 17th. Was still in the doctor's care. So the court continued the matter until today, April 6th, which is more than 30 days. And the defendant is not present. Has the plaintiff heard anything about the matter, Mr. King?
No, Your Honor, we've not heard anything. I'm in possession of photos showing the property. It's not clean. It was taken 2 days ago, but I've not heard anything from her.
All right. Well, I don't really want to order her to be arrested, so what I'm going to do is this. I want to order that she appear. We've got a date, sign commissioner next week, and then if she fails to appear, then she'll be arrested. And then proper report, which is,